Hello, everyone. We're Team 4B, and we're here to talk a little bit about European code law versus US or British common law. We're going to first discuss what is code law and what is common law. Conrad's going to take us through that, and then Landon will take us through why it's important for international businesses to understand. Afterwards, Stephanie will talk about examples of companies that have either had problems or benefited from knowledge in this field. And then I'll conclude us with a comparison and summary of the differences. So here's Conrad to talk a little bit about what code and common law are.
European code law is the application of principles embodied in statutes or law codes, rather than turning to case precedent. Thus, the basis of law in civil law jurisdictions is statute and not custom. European code law began in the 5th and 6th centuries post-Roman rule of Europe, and when the continent was dominated by the Germanic peoples. Among them were the Anglo-Saxons of England, the Franks of Western Germany and northern France, the Burgundians and the Visigoths of southern France and Spain, along with the Lombards of Italy. Although the traditions of Roman law endured for some time, Germanic customs came to prevail in most regions. In the Middle Ages, these customs underwent vigorous growth in an effort to satisfy the complex needs stemming from the development of feudalism and chivalry, the growth of cities, Eastern colonization, increasing trade, and an increasingly refined culture. The system that has thus emerged was called the jus commune, or common law. Civil law. In actual practice, it varied from place to place, but it was nevertheless a unit that was held together by a common tradition and a common stock of learning. As time went on, the French Revolution, among other revolutions throughout Europe, have occurred, and codification grew and established itself as the common body of laws throughout Europe. The idea of code law was to keep the law clear so as to make it accessible to the layperson, concise to make it flexible as unforeseen situations arose, and complete to give it the most applicability and prevent differing opinion on ruling. Coming into our current practice, every country of Europe has its own flair on coded law that has morphed with the changing of the times, that are all underneath the supranational legislative body that is the European Union. However, the EU still holds its roots in both the Germanic and the Napoleonic methods of rule. US common law, however, is a body of law based on custom and general principles embodied in case law, which serves as precedent and is applicable to situations not covered by statute. The common law forms the basis of many countries' legal systems. The common law is based on a precedent-based legal system as opposed to statutory law and legislation like you've seen with the EU. The common law is a strict principle-based reasoning that uses the circumstances of a case to evaluate the laws that are applicable. In the US, courts and judges make law based on principle-based reasoning, and those decisions are followed as precedent. The original source of the common law system can be traced back to the English monarchy, which used to issue formal orders called writs when justice needed to be done. Because writs were not sufficient to cover all situations, courts of equity were ultimately established to hear complaints and devise appropriate remedies based on equitable principles taken from many sources of authority, such as Roman law and natural law. As these decisions were collected and published, it became possible for courts to look up precedential opinions and apply them to current cases, and thus common law was developed. Common law saw its real growth after the American Revolution, when the American legislative branch formalized and established itself as an ever-growing common law system, the system we all adhere to and are familiar with today, a system of principle-based reasoning, circumstantial consideration that is centered on precedent.
An important first step for any business planning on performing operations outside of the country where they normally operate is the legal systems in the country where they plan on operating. There are two specific types of legal systems I'll be talking about, and that is the common law system and the codified law system. There are many essential considerations businesses need to make as they perform business on an international stage, and a lack of understanding regarding a country's legal systems can dramatically affect not only how you do business, but how you report revenue. In a world where businesses are striving to be more internationally focused in emerging markets, these financial considerations can have a large impact on earnings. A specific example of this is, In a common law legal system, you can recognize something known as substantial completion. This is very important for manufacturing companies and construction companies. But in operating in a codified legal system, unless there is a specific provision for that, you cannot recognize that. And that can dramatically affect your revenue. Another important consideration is the protections offered to managers, creditors, and investors. In codified legal system, managers and owners of companies tend to be better protected. And in common law legal systems, creditors and investors tend to be more protected. An example of this would be that in codified legal systems, you actually can smooth earnings if there is not a law preventing you from doing so. And this stands in very dramatic difference of a common law legal system. It is essential for businesses to know the countries in which they operate if they're able to not only operate effectively, but also report their financial statements transparently.
Now let's put into practice what we've been discussing. There are several different examples of businesses that have been impacted by civil and common law when doing business. First, let's talk about Apple. Let's take a quick look at some of their key statistics. Apple iPhone sales generated 52% of the company's $365 billion in revenue in 2021. There were 230 million iPhones sold, along with 71 million iPads and 20 million Mac and MacBooks in 2020. The company also sold 110 million AirPods and 43 million Apple Watches also in 2020. As the statistics and numbers show, Apple has a lot of customers and is generating a lot of business with its products. Most of Europe falls under civil law, and recently the executive arm of the EU proposed a new law that will force smartphone manufacturers to equip their products with a standard USB-C charging port. What does this mean for Apple? As most of you know, Apple does not use a standard USB-C charging port for its devices. The proposed legislation was created to cut waste and make consumers' lives easier by only needing one charger for several devices. The ruling outcome may have a huge impact on Apple because the company still uses its Lightning connector to charge its devices. If the proposed law is passed, device makers will be given 2 years to comply with the ruling. Several companies that produce Android phones would benefit by this ruling, as they already have USB-C ports and will not have to change their devices and products. However, for Apple, it would be a very different story. As can be seen through this example, civil law can either benefit your company or make it difficult to do business. Let's take a look at another example of how common law can affect businesses. Located in New York, Hugo Boss owns a 2-story retail store with a 13-year commercial lease with the landlord AR Retail. The lease includes a force majeure clause excusing the non-performance in cases of war, terrorism, acts of God, strikes, or any order or regulations of or by any governmental authority. And in March of 2020, as COVID began to spread throughout New York, Governor Cuomo signed an Executive Order 202 and declared a state disaster emergency for all of New York. And following this order, AR Retail closed the shopping center, which included Hugo Boss. Hugo Boss paid rent for April 2020, but did not pay the full amount of rent throughout the worst part of the pandemic. Eventually, the shopping center was reopened to the public in September of 2020, and Hugo Boss was once again open for business, even with limited capacity. The store, however, had a significant decline in business due to the pandemic, and even though Hugo Boss continued to stay open, it had not paid the full amount of rent since April of 2020. AR Retail and Hugo Boss both brought separate actions against each other, and in the first action, AR argued claims against Hugo Boss for breach of the lease. Hugo Boss counterclaimed based on the doctrines of impossibility, and frustration of purpose. Ultimately, the court rejected Hugo Boss's argument that pandemic-related restrictions entirely frustrated the purpose of the lease. Even though the pandemic had contributed to several months of shutdown, the pandemic had only reduced and did not completely eliminate Hugo Boss's revenue from its retail store. The court ended up acknowledging that although there were economic impacts from the pandemic, the temporary closure of Hugo Boss and restrictions was not enough to count, as the court have phrased it, rise to the level of triggering an extra contractual common law right to rescind a 13-year lease. So as we can see, common law can also provide difficulties for some companies when doing business.
So to summarize, what civil law or code law and common law are is kind of difficult. They're in-depth topics. So on your sheet, we've provided a little breakdown in a table where you can see the exact differences between the two. So first off, the legal system, civil law or code law, is primarily a set of codified core principles that are the primary source of law. In common law, you have precedents or case law, which is developed through judges' rulings, and those rulings set the main body of law. In sources of law, in civil law, you can see first comes the Constitution, then legislation, which are statutes and subsidiary legislation. Third is customs, and fourth is international law. In common law, constitutions first, if you have one. Great Britain doesn't, for instance. Then legislation, then judicial precedent, then customs, convention, and international law. In some of the countries, you can see here, some of the bigger countries that both operate out of. So in civil law, you have Spain, China, Japan, Germany, some there. And then in common law, primarily English-speaking nations, United States, England, Australia, Canada, India. Here's a map of the world. And as you can see here, most of the world operates under civil law in geography. Okay? And then you have common law nations, which is a large amount as well, but those are the two main ones, and that's why we're just focused on those in this course. So judges, for instance, in code law or civil law, judges are the chief investigator. They make rulings, but they're usually not binding to third parties. And in that system, the role is establishing the facts of the case and then to apply the provisions of the code that's already there. So they basically just apply the law. In common law, the judges make the ruling and set precedents for the future. And they become a referee between the lawyers. And in common law, instead of the judges producing the evidence, the lawyers do. And so these judges, they don't inquire into matters before proceedings, they just mediate, and then they decide when a jury is not present. And then for juries and lawyers, so a jury is almost only in criminal cases for civil law. And they may not need a unanimous decision. Lawyers present the arguments based on the findings of the court, so they don't actually do their own gathering of evidence. And then judges are the ones who ask questions and demand evidences of the parties, not the lawyers. In common law, which is what we're used to in the United States, the juries apply the law based on evidence and facts presented to them in both criminal and civil cases. The lawyers then ask questions of the witnesses, demand production of evidence, and present cases based on the evidence they've gathered. And the judge's job is just to mediate and give the ruling of the jury where a jury is present, and when a jury is not present, to give the ruling themselves based on the facts and evidences that have been provided. Evidence, again, so evidence demands are within the court in code law. So the court, led by the judge, are the ones who gather evidence. It's not within the role of a lawyer. The lawyer just defends their client and speaks for their client. In common law, the litigants and lawyers, it's their job to effectively pursue or defend the claim with both gathering of evidence and presenting the case. So those are the main differences between code law and common law. If you have any questions, feel free to reach out to us on the discussion boards, and thank you for your time.